Well, good evening and welcome. It's great to see all of you here. I'm Ann Murphy, President of the League of Women Voters of Washington Education Fund. And welcome to this Supreme Court Justices Candidate Forum. This forum is sponsored by the League of Women Voters of Washington Education Fund, along with the League of Women Voters of Thurston County, the Olympian, the Black Alliance of Thurston County, the Thurston County Bar Association, and the Olympia Unitarian Universalist Congregation Faith in Action Ministry. And we're presenting to you tonight the candidates for positions 1, 5, and 6 of the Washington State Supreme Court. Ever since the founding of the League almost 100 years ago, a significant part of our mission has been to provide nonpartisan voter education. Integral to that mission is that the League is nonpartisan. While the League does act in support of or in opposition to selected governmental issues, which our members have studied, it does not support or oppose candidates, factions, or political parties. League members as individuals are urged to work in the political party of their choice. Our goal here is to then provide you a venue to hear from the candidates. This forum is an opportunity for these candidates to present their views and positions on all things judicial that we can talk about, so that you, the voter, can make a more informed decision when you mark your ballot. At this time, I thank the work of Pat Dickinson and the Thurston County League team for making this forum happen. So thank you to all of you. The League is also sponsoring other forums around the state for other statewide offices. We are pleased to be working in partnership for TVW to extend the reach of these forums throughout the state. Forums are being taped by TVW as well as local TV stations and will air in the coming weeks. With that in mind, there is to be no other taping in the auditorium. Each candidate understands that this forum will be rebroadcast in its entirety, and in that spirit, we ask that you put away your recording devices, both audio and video, and be present with us live tonight. It also gives the candidates confidence that their words won't be taken out of context. So thank you for turning off your electronic devices. You can find up-to-date information about airing schedules and links to the, all of the forums at LWVWA.org. Additional viewing information is also available at TVW. The League also sponsors an online voters pamphlet with candidate and issue information at vote411.org. And most importantly, in order to vote in the general election by November 8th, you must be registered to vote. And I imagine you all are, right? But if you know of somebody, a new voter who has not registered, they still have that opportunity to do that at your local elections office by October 31. Our Vote 411 site has more information. Additionally, there's more information here in the hall tonight. So thank you for your interest in the election process, and we hope that you find this forum helpful. And now I introduce you to Pat Dickinson, President of the Thurston County League. Pat?
Well, thank you. You don't need to applaud at everything. The League of Women Voters of Thurston County is delighted to join in welcoming you to this forum. We're just really tickled to have you all here. And we've partnered with the Olympian and the other groups that Ann mentioned to bring you this forum, and then we have this wonderful coverage by the media, TC, TV, and TVW, and an independent person. So we're well covered. And to stress, the League never supports or opposes candidates, and never supports or opposes political parties. We are nonpartisan. We work collaboratively to influence public policy through education and advocacy. We see this forum as a great example of collaboration between all of the groups that have worked to put this on. So I cannot resist the opportunity to plug membership in the League of Women Voters. And you are welcome to go to our website. It's LWV. You just type in League of Women Voters, Thurston County, and you'll get to our nifty new website that we just redesigned. So take a chance. Do it. You'll be glad you did. What? We'll, as Ann said, also we'll put the TVW videos up so that you can link to them. We'll let you know on our website. So I finally want to reiterate something that's in your program. It's about the Supreme Court. And it says, the Washington Supreme Court is the head of the judicial branch of state government, co-equal with the legislature and executive branches. It is the state court of last resort. It consists of 9 justices being chosen by the voters from a nonpartisan judicial ballot at the general election in November of each even-numbered years. So that's where these folks are campaigning for. Now, it's my great pleasure to introduce our moderator, who's Austin Jenkins. Since January of 2004, Austin has been the Olympia-based political reporter for Northwest News Network. In that position, Austin covers Northwest politics and public policy, as well as the Washington State Legislature. You can also see Austin on television as host of TVW's The C-SPAN of Washington State, Emmy-nominated public affairs program Inside Olympia. Prior to joining the Northwest News Network, Austin worked as a television reporter in Seattle, Portland, and Boise. Austin is a graduate of Garfield High School in Seattle and Connecticut College in, New London, Connecticut. Austin's reporting has been recognized with awards from the Association of Capitol Reporters and Editors, Public Radio News Directors Incorporated, and the Society of Professional Journalists. Austin.
Thank you, Pat, for that very nice introduction. And just see if I can get this to work here. There we go. It's very nice to be here. I'm glad this is great. It's a packed house. I've been unstacking chairs back there. That's fantastic. This will be a really interesting evening. The Supreme Court races are often don't get the attention they deserve. They are further down ballot. In a year where the presidential race seems to be sucking all the oxygen out of the room, it's kind of amazing that we are all in this room together, and we're going to talk about something besides that race. Let me just I cover the legislature and the court, but I'm going to use a term that they use up in the legislature, a point of personal privilege. Before we launch into this, I just want to mention that Barbara Tice, who was the League of Thurston County League of Women Voters of Thurston County Voter Services Chair, started to organize this event. And then she got sick. She was hospitalized, and she subsequently passed away. Besides her role with the League, Barb was also my former neighbor. And so she called me a few months ago and asked me to moderate this. And how could I say no to Barb? So I said, of course I would. And in fact, she had recruited me to moderate a Department of, or a Lands Commissioner forum as well. So there's some sadness in my heart tonight that Barb is not with us. She was a tremendous person. What I would say about her is that we always saw her out walking twice a day. She had a wonderful smile. She was great with our kids. And she also just embodied what it means to be a civically engaged person. So if you know her, if you knew her, you know what I'm talking about. If you didn't, I will just tell you that her spirit is in this room. She will be missed tremendously, and I'd like to dedicate tonight's forum in her memory. Now I will explain the forum procedures and how you can participate tonight and ask a question. There is an audience handout that I think has been mentioned that includes the biographical information about our candidates. If we went through all of that live, it'd probably take up the whole time that we have this evening. So you can read that. That includes information about what the justices do, how they are different from the other branches of government, a few ground rules for tonight's forum. The justice positions are a little different than other elected officials because these positions require you to basically discern judicial temperament and approach. We aren't really able to just ask, how would you rule questions? Well, we could ask them. I think they might not answer them. Due to the time constraints, we're not going to do opening and closing statements by the candidates. However, the way that we're going to frame these opening and closing questions may sort of elicit some of the information you might glean in an opening statement. The candidates did not receive our questions in advance. We're going to ask that the questions that you generate, basically that you write them down in a 3x5 card, and they will be made available to you during the forum. You can write your question, there'll be somebody to pick it up, and then they'll make their way to me a little bit later on. The question should be addressed to all the candidates. If you'll do that, that would be great. You basically pass them to the end of your row, and the league volunteers will pick them up for use at about 7:50. The candidates are all going to be asked the same questions. So as your moderator, I will ask a question to a candidate at one time. The order the candidates are asked to respond will differ with each question. That may be the hardest part of my job. You can keep me on task. I think I figured out how we're going to do this rotation, but you're allowed to call foul if I mess that up. Each candidate will have 1 minute to respond. In lieu of rebuttals, this is where it gets kind of fun, each candidate will be given one challenge card. Do you have a card or a paddle? Something to smack me with? Wow, okay.
It can only be used defensively.
Right, exactly. And here's how that works. At the conclusion of any question, after all the answers have been given, a candidate may use his or her challenge card to take issue with something that another candidate stated. The way that this would then work is that the challenging candidate has 45 seconds to state their challenge. The challenged candidate has 45 seconds to answer the challenge. And again, each candidate only has one challenge card to use during the entire forum. Time limits will be strictly enforced. Our timekeeper, it's right there, will hold up two signs to the candidates. The first when there are 30 seconds remaining, the second sign when there are 10 seconds remaining, and then a bell will ring when time goes up. Great. And if necessary, I guess I will interrupt and maybe try to take one of those paddles from you or something. I don't know. Please be respectful of the candidates. Not that you wouldn't. Hold your applause till the end of the event. Turn off your cell phones. I think I remember to do that. And let's get started here. If I can find the questions. What I want to do first is introduce. It's important. We have to have the order here. We have to have the questions. And then we need to introduce the candidates. Let me just run right down the line here. So basically, you're meeting tonight 3 sitting justices of the Supreme Court and 3 challengers to those justices. So on the end is David DeWolf, Justice Mary Yu, Chief Justice Barbara Madsen, Greg Semple, Dave Larson, and Justice Charlie Wiggins. And here's the order that we're going to do this in. We're actually going to start down there, run down the line, and then kind of take turns, I think is how we're going to do this. So the first question will begin with David DeWolf. And the question is, each of you has served the legal profession in a number of capacities at a number of levels. What in your background and experiences has best prepared you to serve on the state Supreme Court, and when did those experiences occur? Go ahead.
Thank you. It's great to have all of you here. I've taught law at Gonzaga Law School for the last 28 years, and my entire career in legal education and practice of law has taught me the importance of taking the long view. That is, when issues come up, it's tempting to look at the immediate solution in terms of what would happen in the next year or 5 years. But one of the jobs of a state Supreme Court is to think of the law in longer terms. In teaching the history of law, going back to the time of Hammurabi and more recently, courts often get in the wrong position by looking at the short term and not seeing the longer picture. And I think my background teaching the law has given me the perspective to see the importance of making decisions that are good for centuries and not just for years.
Okay, Mary.
Well, you know, I think that what makes me uniquely and best qualified for this position is the fact that I have served as a trial court judge for 14 years. And while I appreciate the long view, the reality is that each case is about real people and ordinary lives and affects the people in the state of Washington. So you have to have some sense of being grounded in reality. It's not just an academic experience in terms of what we do. We address and resolve cases that not only involve constitutional law, but family law, juvenile, criminal cases. So it's a whole host of different kinds of cases that come through our courts. So I believe my experience in the trial court as a trial judge is what makes me uniquely qualified. And then prior to being a trial court judge, I was a prosecutor in the King County Prosecutor's Office. So I have immense respect and knowledge of what happens at the trial court level.
Barbara Madsen.
I think what best prepares me is the last 24 years that I've been doing this job. It's important to have well-balanced experience and a committed community spirit in the justice that you choose. My experience was as a public defender, as a prosecuting attorney, as a special prosecutor. I worked for legal services for 2 years as a volunteer. I raised 4 children in my community where I also volunteered with their schools and with all sorts of other community activities. I was elected to the trial court, so I saw real people every day who had real problems, and I had to be fair and listen to them. And then I've spent the last 24 years deciding the most important cases in our state. And the last 7 of those years, I have been the Chief Justice, elected unanimously by my colleagues. Believe that those things are important for a judge. Well-balanced, experienced, well-rounded human experiences.
For example.
Thank you. 22 years as a prosecuting attorney, elected prosecuting attorney, experience that's not on the bench, 22 years of trying every type of criminal case, 22 years of trying hundreds of cases, 22 years of being on the civil side of local government, representing local government on the issues that come before the court. When you talk about local government issues and criminal issues, 80% of the cases coming before the Supreme Court are the cases that I've handled for 22 years. Before that, I was in private practice, criminal defense, and general civil. I've also spent half of my life living on the west side, growing up in North Seattle, half of my life living on the east side of the mountains. I also have a family that's very complex, has allowed us to become foster parents, to do a number of things in the communities, develop drug courts and mentoring programs. When you want to talk about well-balanced, I'm that candidate.
Dave Larson.
Thank you for the, thank you. When that question was asked, my life kind of flashed before my eyes. What led me here? And it seems like just about everything I've ever done has led me here. Whether I was the 12-year-old kid selling firewood and pouring patios and sidewalks with my dad to help make the house payment, whether I was a kid that worked my way through college and law school, working full-time and going to school, working as a trial lawyer, trying 70 jury trials, 250 arbitrations, a trial judge now for just under 9 years, seeing thousands of cases. Everything seems to be leading me here. But if you had to pick one skill set that I've developed over the years that I've had a proven track record of, and that's the ability to bring people together. Now more than ever in all levels of government, we're splintered. And the court is splintered now. Whether you agree with what the court's done or you don't agree with what the court's done, we are in a position where we have to move on from here. And my skill set has a proven track record of being able to bring people together and move on to a higher level. I've done it at the Federal Way Municipal Court. I've done it at the Federal Way School Board. I was a school board president. It just seems like everything that's happened in my life brings me sitting right here and to my choice. And as I proceed further, I'm more solid in my choice. Thank you.
Charlie Wiggins.
For 40 years, I've practiced law, and during all of that time, I have been a litigator, other than the time that I've been on the court. I've tried cases in Superior Court in a number of different counties in our state. I have tried cases as a pro tem judge, a substitute judge in King County and in Jefferson County, so one of our largest counties, one of our smaller counties with only one judge. In addition, I've done appeals, and I've done appeals for my entire career. That really is the best preparation I could have had for this job, because what we do in the Supreme Court, our primary responsibility is to resolve questions of law through focus or through the lens of a specific set of facts in a specific case using the briefs prepared by the parties. And so my experience as an appellate lawyer has been invaluable. I've also been a judge on the Court of Appeals, and with that, I'm going to stop. Thank you.
There you go.
Okay, second question is, do you think that Supreme Court positions should be statewide offices, as they are now, or do you think that the positions should be localized, where each candidate must live in the district that he or she represents? Please explain your reasons and give examples. And we'll start with Mary. You work down the line and then come back around to David DeWolf. You don't need to wait for me to signal your turn unless there seems to be some question. Go ahead.
Well, I think Supreme Court justices ought to be elected statewide. We are state officials, and we're the branch of government that does not represent people. We really are focused on the law. We're trying to make decisions that are not based on who we're so-called representing. Frankly, I could be elected in King County till I die because I've lived there and I was elected there as a trial court judge. But I believe that at the state court level, you have to have a statewide perspective. And you need to have that in mind. I don't think that requiring that you live in a particular district really serves the court or serves the whole idea of a statewide elected office. So no, I don't think it ought to be by judicial district. And again, more importantly, we don't serve a particular geography or group of people.
Go ahead, Barbara Madsen.
I think I would echo what Justice Yu said, that this is a statewide position and we do need a statewide perspective. But on a practical level, at one time when I first came onto the court, a number of people lived in Seattle and they commuted down from Seattle. And even then, it was tough to get them into the building. When you don't have your colleagues at your elbow that you can go to and consult with, we are a collaborative court. We have to agree, 5 of us have to agree to come to the resolution of a case. If your colleagues aren't there when you have a question or when you want to share your views, it makes it much more difficult. Beyond that, if you have election from districts, you have to live in your district or you won't be reelected to your from your district. And my experience is that if you don't, the farthest away you can live and still be a functioning member of the court is someplace like Seattle or maybe Vashon. We have a couple of colleagues, I think, from Vashon or Bainbridge. But beyond that, you move there. You're going to move to Olympia, so you're not going to live in your district. So.
Fundamental difference, I do believe that the Supreme Court represents people. They represent all the people of the state of Washington. I've heard the statement that it's not a representational body, but at its very core, the state Supreme Court is in place to interpret the Constitution vis-a-vis the actions of government against the people. And in that way, their primary role is to be a safeguard of government action against the people. It is a representational body. I don't buy the concept that you cannot have geographically elected justices. There is nothing that says you have to live in Olympia or within the I-5 corridor. Part of the problem is that if every justice, 8 of 9 at the present time, come from the greater Puget Sound area, there is no diversity of life experiences, no different opinions that are brought to the discussions. We've tracked commuters in Ellensburg starting in 1990 when there was 50 that traveled over the mountain on a daily basis. It's up to 5,000. People travel to Olympia every single day from Ellensburg.
Well, I look at it from a very practical standpoint. We have population centers that are condensed and most of the voters live there. And so people that are familiar to those voters are going to get elected to the Supreme Court. Any change would require a constitutional amendment, a vote of the people, and if it was approved by popular vote, that would be fantastic. I'm going to approach it from an appearance standpoint. Like, for instance, controversial issues that involve rural areas, when they're decided adversely against rural residents, and they see the justices all living in urban areas, there becomes a question of the confidence of that decision. And that's where the real issue is. And so from a public policy standpoint, when you're debating that issue, it's not just about the mechanics of where justices are from. It's about the appearance. It's about the sense of justice that people have if all the justices are from a particular area and they constantly see decisions being made in rural areas that may not represent the needs of those rural areas. So that's where I approach it from a public confidence standpoint.
We are interpreting a state constitution and we are interpreting state laws that were passed for the entire state passed by a legislature consisting of people from all over the state, signed by a governor who runs statewide. It makes sense for us to be statewide candidates. There's a practical side of it too, which is that when you come to an election, here we are. And we do get out and we go to the far corners of the state and we do learn about the concerns of people and we see the concerns of people. I think also there's some overstatement about we all live in one place. I think you might be interested to know that 2 of us live in Pierce County, 2 in King County, 2 in Kitsap County, 3 in Thurston County, this county, one of whom really is from Spokane and really is a transplant from Spokane. So we actually do represent these counties, although we're all on the Sound, we all are very different, and so we do have a variety.
Okay, David DeWolf.
I testified in favor of a bill to amend the Constitution to permit election of justices by judicial district. It is true that the justices serve the entire state, just as each legislator serves the entire state by the laws that they pass. On the other hand, I think it helps, for one thing, to focus the election on a smaller geographic area. We would all testify at the difficulty of trying to run a statewide campaign with the limited resources that are available for judicial elections, whereas a smaller district would allow for a more concentrated campaign and a comparison of views in a more realistic way. You wouldn't have to live in the district. I agree with the Chief Justice that as a practical matter, you have to live in Olympia to do the job. But being elected from a district would still be possible to ensure that there is accountability for the entire state reflected in that geographic diversity.
Okay. If judges hold views on issues that come before the court, how can they impartially rule on them? Should judges make their views known, their biases known? Why or why not? And we'll start with Barbara Metz.
Well, we, of course, take an oath to uphold the Constitution of the State of Washington, the Constitution of the United States, the laws of the State of Washington and the United States. And really, as a person who's been a judge for almost 30 years now, what you have to do is learn how to acknowledge your own biases and then set them aside. If you can't do that, you should not be a judge. And I will say that that's partly why I think it's important for someone to have had some judicial experience before going on to the highest court. These are very significant cases that we decide, and many of the issues we do have opinions on. So if you haven't learned how to set aside your biases, it's going to make it a much more difficult and challenging role to be your first role as a judge. But, of course, we're all human beings, and so that's why we try to talk about our backgrounds, where we came from, what our experiences have been, and people can relate to those things, and I think that's the answer.
Okay, I'm going to have everybody pull their mics in a little bit closer. I think some of the folks at the back of the room are having a hard time hearing, or you can lean in, whatever works. Greg Semple, go ahead.
I think that the justice is right, Chief Justice is right. You have to be able to set issues apart and beliefs apart. Same thing for a prosecutor who's elected to run an office. You take an oath for that office just as you do for the Supreme Court. And as a prosecutor, you do the same sorts of things on a daily basis. People expect you to perform justice, whether you're a prosecutor or whether you're a Supreme Court justice or a trial court justice. I would say that we need to do a better job of allowing judges to talk about those biases at the front end. I would work to pull the cannons back a little bit. As a prosecutor, people expect me to say what I believe in, express my opinions, and be accountable for that. We don't give that free rein to judges. If we did, we'd have a better sense of what their biases might be, and we have processes for them to step aside if those biases can't be overcome.
We swear an oath to uphold the Constitution. The first thing that happens is we lose our constitutional right to speak, and I'm fine with that because I think the people have to have confidence, or know up front that there's not going to be biases, and if there's a duty on the part of a judge to, as Chief Justice Madsen said, to overcome their personal biases, and if they can't, then they shouldn't hear the case, and if they can't on a regular basis, they shouldn't be a judge. And the test that in judicial elections is that's the primary thing that we need to look at. is the ability of a person to overcome their personal prejudices, to apply the law and the Constitution the way it's written. If you can't do that, you shouldn't even be in office. And I find it liberating to not have to be beholden to any particular views, to look at the law and the Constitution and apply it the way it's written. It's all about dignity. And that's where you give people dignity, is to have the law be predictable when they come in and know that they've been treated fairly and know that a judge has put aside their biases.
Socrates said, "Know thyself." And that's really the first way that you try to put your own biases aside, by knowing yourself and recognizing those things within you. Now, we have some disciplines that we use to help overcome our biases. And those lie in the way we interpret the law and the way we interpret the constitutions. A couple of constraints here. When we interpret statutes, we're governed by the words of the statutes, and we try to discern the intent of the legislature. And that's an important discipline, because if we're working within the language of the statute, we have to give credence to every word in the statute, not take words out and ignore them, not put additional words in. And that discipline is a discipline you acquire through practice. And it's a discipline that makes a big difference. And it's one of the things that you really do on the Supreme Court a great deal. And it's a great learning curve. Thank you.
Well, one person's conviction is another person's bias. None of us we're not a blank slate, but as has been said, we're trying to apply an objective standard. I think if you were an umpire in a baseball game, you might have a friendship with one of the players, or be rooting for one of the players to make a record or do well. But overall, your concern is that the game is played fairly and that you apply the rules to the same extent to each player. And I think when you take an oath as a judge, you take a similar commitment to deciding the cases fairly, and that becomes a higher value than your own personal preferences for who you would like to see succeed or some cause that you would favor. And I think it's incumbent upon the voters to examine the history of each candidate to determine whether they've demonstrated in their life an integrity of character that would allow them to fulfill that expectation.
Well, the advantage of going last is to say, wow, I agree with almost everything that's been said. And the only thing that I would add is the announce clause of the canon serves also a purpose in enhancing confidence in the courts. And that's why judges should not be announcing views in some way. And I'll give you an example. And God bless him, he's now no longer with us, but when Justice Scalia would get up and talk about the death penalty or his support of it, it undermined the confidence that anybody had in terms of his ability to actually decide a case that would come before the court. If you were sitting in prison, you would wonder whether or not you would really have a fair shot at having your case heard if it was a death penalty case. That's just an example to say the announcement clause undermines or supports the whole idea of that judges should be, again, fair and not announce views in public, because it also serves to undermine confidence.
Let's stick with this theme, if you will, about sort of integrity of the court. This is a question about recusals and when a justice should recuse themselves from a case. I don't believe it happens terribly often, but the question is specifically here, this is kind of a specific example. If judges have a financial interest in a company that could be affected by a case before the court, should they recuse themselves? Do the rules currently require recusal in such cases? Please explain why or why not. And we're going to begin with Greg Stemple.
Well, I think the concept of recusals is present at just about every level of government. It's a built-in safeguard. It goes back to what do we know about our people who are making decisions, and what don't we know about our people? What obligations do they have to inform us about the conflicts that they have? And sometimes, whether or not someone is involved financially with the company or not involved with the company is hard to find And so we place limitations on folks and requirements on folks to make those known. I think as a judicial officer, it's incumbent upon you, if you believe that there is any hint that you could be called upon for having a bias because of personal involvement, that you need to be looking at the necessity of recusing yourself. I think that when you look at interests of all sorts, you should be looking to see, does the public, looking at the entanglements I may or may not have, believe that there is a conflict? And if it exists, you need to have a discussion about that at a minimum and recuse yourself if you have that financial incentive.
Yeah, the ethics rules are a floor, they're not a ceiling. Each of us are allowed to interpret the rules as long as, in a way that we feel is the most appropriate, as long as it's above that floor. We go below that floor, then we create problems. For me personally, that case, just even if there wasn't a technical recusal required under the rules, it creates an appearance issue, and you should recuse yourself. I'll show you how far I go. I had a person in court yesterday that I coached in Little League 13 years ago, and I made sure the lawyers knew that I coached this kid in Little League 13 years ago, for the parties to have an opportunity to be heard. And the parties have a right to know what those connections are, so they can be heard on that.
I think when you are looking at financial interest in anything that comes before the court, you're really in an area where you probably need to recuse if you have a financial interest in the outcome of the case. I mean, that's very clear from the rules. But there's a balancing act that's involved here, because we have a duty to be fair, we have a duty to be really above suspicion, but we have a duty to sit. We are elected to sit in these cases. And so the ultimate test that any one of us has to ask is, can I be fair in this case, and is it reasonable for people to think that I can't be fair? So it's both an internal check as well as an external check, an objective check. And when you come to the court, first, when I came to the court, of course, I came from a very active appellate practice, legal practice, and for a number of years, I had to recuse or remove myself from a number of cases. I'm done with that now, pretty much.
The current rules pretty much leave it to the individual judge or justice to determine whether or not they have an interest that would prevent them from deciding the case fairly. As Justice Wiggins pointed out, there is a duty to serve as well as a duty to recuse oneself in the appropriate case. I think my approach would be to take those questions, those close issues, and present them to my colleagues to basically say, do you think this is a barrier to deciding this case fairly? And instead of putting all the burden on the individual to make this decision, to essentially make it a more collegial decision in light of the fact that the court does have not only the actuality of fairness, but needs the appearance of fairness in order to maintain confidence in the judiciary.
Well, you know, as judges, we are always taking a look at various conflicts, and that could be a financial interest, it could be other interests that you might have in the outcome of a particular case. And I think each one of us gets into the practice of examining that and asking whether or not we ought to recuse. But simple recusal isn't always the answer. Sometimes it is disclosure and allowing the parties to have some input. I think Judge Larson referred to that as somehow how do you engage the parties or disclose it so that everybody knows, because a real important value in all of it is not only asking yourself, is there a self-interest, but is there transparency in terms of how we make decisions and what the interests might be that we have.
It's a little different on the Supreme Court, because if a trial court judge had, there was a question there, there's an affidavit of prejudice that can be used. There's no such thing in the Supreme Court. So it puts more of a burden on the individual justice to examine their own views and whether or not it's easy in a financial conflict, but it's not so easy sometimes when there are other kinds of conflicts. So I think that because there is no affidavit process, we have to err on the side of at least disclosure, if not recusing. My first experience with recusal was a visceral reaction to a defendant pushing his pregnant wife down a set of stairs. And I really just recognized in myself that I couldn't sit on that case because I just really wanted to throttle him. So that was the first time I recused. The second time I recused was because I had actually issued the orders that started the whole case, and I said, I can't overrule myself. It would be really hard. Every case is going to be different.
We'd like you to share your personal opinion about the value of diversity on the Supreme Court bench. And I suppose you can define diversity as you see it. But how important is it? What is the value of diversity on the Supreme Court bench? And we're going to begin with Dave Larson.
Well, diversity is very important, and I mean, again, that's such a multi-level, multi-layered question. You have diversity of views, diversity of race, diversity of gender, diversity of all these different things, and I think that it's absolutely important. And I'll tell you a story, and I hope I can get it done in a minute. I mediated a case where a couple trying to stay together. I'm going to tell it fast. They were married 46 years, right? The husband was a Boeing engineer. He helped us get to the moon. He justified his position on being real risky with the money in retirement by telling me it wasn't for people like me who would have never made it to the moon. Well, his wife was very conservative, wanted to be very thrifty. And my response to him is, if it wasn't for people like your wife, we'd have never made it back. And you have to have diversity of views, diversity of opinions. In a collaborative body like this with 9 different views on the important issues, you have to be able to not only want diverse views, you have to embrace diverse views, embrace dissent, embrace disagreement.
I think you're going to probably hear each of us say diversity is important on a court, any court, and particularly on the Supreme Court. One of the virtues of having 9 justices is you get people with different backgrounds and different experiences, and you achieve a level of diversity just through numbers. But what is important about it is that it brings to the table or to the conference room a variety of views and a variety of the ways of looking at things. And frankly, I've found that incredibly valuable in cases as we have discussed them, because we do have a variety of folks on the court. And as was said already, diversity can take many forms. We were in a forum, might have been the League Forum in Spokane, and we're asked about diversity. What diversity do you bring? And someone said to me afterward, well, you should have told him you're a veteran. You're the only veteran up there. And I thought, well, I guess that's diverse.
We have an adversarial system in America, which is a reflection of the fact that we don't look for the truth to come in a unified package. We look for the comparison of contrasting views, and we expect the lawyers to present the best arguments for both sides. And I think that's what you strive for on the Supreme Court, is a similar range of opinion in order to arrive at the best outcome. And so the diversity, as we've talked about, diversity of experience, of race, of gender, of background, and so forth, those are all in service of this larger purpose of making sure that we've heard the best arguments from a variety of different points of view, and after we've heard that, we can arrive at the best decision. And so I think our whole system is based on the idea that in diversity really is our strength.
Boy, again, I want to agree with almost what everybody is saying, and that is, first of all, there are diverse perspectives on the court, so you need to know that right now that exists. But I also don't want to water down diversity just to mean everything, and I want to offer myself up also as Exhibit A of diversity in terms of race, sexual orientation, gender, and I think that is particularly valuable today as you look at how people feel about our court system. Minority populations have very little confidence in the court system across the country because they look up at a variety of systems and don't see themselves. And so I want to just say, I think that our court really is diverse in perspective. I think we are diverse racially and certainly by gender. And it's an achievement and something that we all ought to be proud of. But I also think it's valuable and it brings value to the court.
When I was elected in 1992, I was only the third woman to serve on the Supreme Court in the 103 years since it had been organized under the state constitution. And the reason that I ran for the court in the first place was I was watching the Anita Hill, Clarence Thomas hearings, and there was not a woman senator in that chambers, and I couldn't believe the treatment that Anita Hill suffered at the hands of those senators because they had no ability to walk in that woman's shoes. And I think that's really what it's about, is making sure that there are people who can relate to whatever it is that they're hearing, and it's not just, as Justice Hughes says, about a diversity of opinions. That's important too, and you're going to get that because every one of us is a unique human being, but you really, when you walk into a room and you haven't seen a woman or a person of color on the bench, and you are a woman or a person of color, it matters to how you feel about whether you're going to be treated fairly.
Very simple.
I would agree with most of the comments made. We understand the value of diversity across the board. I think most people who would be running for this position have gotten to the point where they understand the importance of diversity. I first learned it volunteering for the busing program in North Seattle, clear back at the start of that. I learned the value and the hardships of diversity from my two openly gay cousins. I learn it every day from my foster boy who was left high and dry when his parents were removed to Mexico. We do need more people of color on the court, and it is important that we don't water down the issues of diversity. But the other issues at that level, the diversity of thought, the diversity of background and different experience are also important at that level, and that's what I bring to the table in that regard.
So a former colleague of mine who covered the legislature said that it finally dawned on him that you can really just boil down what happens in the legislative side of the House to labor versus management. So here's a labor versus management question for the candidates on the judicial side. And that question is simply, have you in your law practice ever represented a labor union or an employer company at any time? And if so, which union or employer did you represent? And I would just add sort of how that perhaps does influence your approach to the law. And we're going to begin with Charles Wiggins.
I actually represented the Association of Firefighters on one occasion, and I also represented the Council of Police Officers and Sheriffs, or Police Chiefs and Sheriffs. There might be one or two others that I've represented, but those were both in the context of filing an amicus brief in the Supreme Court, and they're both in the context of bringing the law before the court and bringing the focus of a particular organization before the court. In terms of employers with union issues, I'm not sure I could really speak to that. And how has that affected me? I don't think that experience really changed my views or caused me to rule more favorably for unions.
Okay. Let's go back down to that end of the table.
In my practice, I practiced law for 4 years at Lukens and Annis in Spokane, and during that time and since then, I've often been asked by employees to represent them in disputes with their former employer or their current employer. And when I was serving on the board of the Artisans, which is a nonprofit for developmentally disabled adults, we had many personnel issues that I had to handle from the employer's side. I've never represented a labor union, but I think one of the most important features of the law is to make sure that in the employer-employee relationship, we have both clear expectations so that each party knows what their rights and obligations are, and that we also have appropriate remedies in the event that that relationship breaks down.
When I was practicing in King County, I was representing the employer, and that's because I was representing King County. So I was never represented an employee or a union. I was a member of a union as a deputy prosecutor on the criminal side. So I would say what I learned more than anything from that whole experience was process, that process really matters, and sometimes people just want to be heard. And that often is what comes up in employment situations as part of the problem, is not being heard and the lack of process.
I've never represented a labor union or management in my line of work before I came onto the court. However, once I joined the Seattle Municipal Court, I became the chief of that court, and it was the responsibility of the chief to do what we called Loudermill hearings, which are the progressive disciplinary hearings when there are challenges to employee conduct. And so I worked closely with the labor representative in the court and conducted several hearings. I felt perhaps what Justice Yu said, that procedure matters, that you have to make sure that everybody has an opportunity to be heard, and that's it's true in every kind of case that you represent people, is that they want to be heard, they want to be treated with respect, and that goes for both sides, and I found that to be very, very important when it came to discipline and someone's livelihood.
So full disclosure, my father was regional vice president for IBEW. My brother currently works for the heavy machinist. I worked for a pension plan. I have also been the county prosecutor representing county government in union negotiations. I'm also in a smaller county where the hats sometimes get changed around, where you have people who come to the prosecutor under a whistleblower policy, and all of a sudden what you're doing and how you're doing it gets a little complicated. How you set those differences up in addressing that becomes complicated. So I've been on both sides of the issue. I would agree that it's about a good process. I would agree it's about being heard, but at the end of the day, the most important thing that people look for is, from both sides, was the process fair to all involved, and did I feel that I got a fair shake as we went through the process? Were the rules followed? Was a just result reached? And that's the best you can hope for in any system that balances employer and employee needs.
I was primarily a tort lawyer when I practiced for 23 years. I was a trial lawyer that did tort cases. So as a lawyer, I wasn't involved in that, but I lived it. My dad was an airline mechanic, and I lived through what's called the Mutual Aid Pact, where when Northwest was on strike, the airline was actually getting paid by other airlines to stay on strike. $46 million Northwest made for not flying an airplane for 6 months. And so the injustice of that's that story of the 12-year-old kid out selling firewood and everything. I've signed both sides of a paycheck. I've worked for minimum wage. I've been an employer. I negotiated with my clerks union, the Teamsters, and I didn't have to, under GR 29, give them a safety valve for adverse employment, but I did. I allowed them to have appeals to jams, because I felt that they needed a safety valve, and I felt that that's fair. And I'm proud to be endorsed by a spectrum from the Associated Washington Business all the way to 3 Teamsters locals.
Okay. So I should probably note that the League of Women Voters came up with the questions for this forum, and part of what they're really trying to do is have this be a way for the average voter to get to know the candidates on the ballot. I also know we have a lot of attorneys in the room. So kind of bear with us as we talk about questions that may or may not particularly speak to you, but it's also an opportunity to get to know these candidates, and these questions are really designed to do that. So the follow-on question is, kind of coming back to your opening statement or opening response, was to tell us a little bit more about your work in the case of the justices before you were on the Supreme Court, and for the challenging candidates about your practice in the law over the past many years. So the question is, what is or was your specialty when you were practicing law, or as you practice today? How many years did you practice in that specialty, and what else should we know about how that experience shaped your approach to running for this position? And I believe we're back to beginning with David DeWolf.
My primary interest in teaching has been tort law, and I've, over the course of years, written the standard reference book in Washington, 2 volumes now. Started out as 1 volume, now it's 2 volumes, Washington Tort Law and Practice. I also wrote a book on contract law and practice. Again, they're the standard reference books. They've been cited over 100 times in the Washington appellate courts, used every day by judges and lawyers. One of the things that had fascinated me about tort law is the importance of balancing the interests of, on the one hand, we want full compensation when we've been injured by someone's negligence, and at the same time, We don't want to be burdened by overbearing tort liability that will restrict our ability to have access to the things that we want in life. So it's been a rich experience for me, both teaching and writing.
Well, for me, I think probably I can pinpoint and say that the focal point of so much of my life was the trial court. I would say, and hopefully don't sound too proud, I would say I'm really an expert on trial procedure and what occurs in the trial court. I know it so well after doing it 14 years, almost 7 days a week it felt like, but I think that that's been the heart of what I have done and what I could say really prepares me for this job. The other, and I think the other justices will say the same, is the administration of justice. We not only hear cases as judges, but we're also responsible for the administration of justice, and I've spent a lot of time on court rules, on the Minority and Justice Commission. There's a host of other things that the court is concerned with as leaders in this whole system of justice, and I've played a role in that. And then finally, I also teach at Seattle U Law School because I believe it's really important to mentor young lawyers. So for me, that's what drives me, that's what gives me life, and what my passion is about.
Well, I spent about a little bit more over 11 years doing prosecution and criminal defense, and I think what I learned from that experience is that there are issues on each side, and that it's very rare to find that there's no value on one or the other side of the argument. And you have to understand and respect that both sides have a responsibility in the system. I also learned quite a bit about the balance between the rights of victims. They need to be treated with respect. The process has to be fair. They have to feel that they haven't been re-victimized by the process, and the rights of the criminal defendant, which are, of course, embodied in our Constitution. And so those are very important and central lessons that I learned. I spent my entire life in a courtroom because that's what prosecutors and defense attorneys do. That's what I did as a trial judge. That's what I do now. And thank you.
24 years as a prosecuting attorney or defense attorney litigating cases, trying well over 100 cases. I would say being a litigator is something that I'm very, very good at. I'm also very good at teaching. I'm also very good at communicating. I've been the president of the Prosecuting Attorneys Association, president of the County Officials Association, and leading those two groups requires a great amount of communication skills to bring them together and move them forward. It's also been recognized as I've been asked to train prosecutors, criminal defense attorneys, and law enforcement officers at the local level, the state level, and even at the national level in South Carolina. With that comes a recognition that every part of the system is important, and you cannot ignore one over the other, and you have to know what you're doing in a wide spectrum of areas, and that's very true when you get to the Supreme Court as well.
I was a trial lawyer for 23 years before I became a judge. I tried complex civil litigation. The last case I worked on was damage to the King and Queen of Thailand's brand new 737. And I did aviation, I did mass torts, I managed litigation nationwide, 15,000 lawsuits I helped manage. Supervised some of the best lawyers in the country. I tried, like I said, 70 jury trials, 250 arbitrations. I think if you added up all the justices, they wouldn't equal my trial experience, civil trial experience. As far as a full-time judge, I've had criminal and civil experience. The life-changing thing, the quest that brings me here is in 1998 or 1997, I handled a wrongful death case that changed my life. It taught me that we need to change the way we look at things, that what people are craving for out of our justice system is dignity and respect. And everything I've done since then is my job as a judge. Everything else is about that. And I really think we need to fundamentally look at how we deliver justice to people. And I think we really got to do that. And that's my passion.
I've been a litigator really for 40 years, other than the time that I've been on the court. And in that litigation, it's been both trial experience, as I said in my opening statement, or my response to the first question, as well as an appellate lawyer. And with the respect to the appeals, that is what we do on the Supreme Court. We read briefs, we research the law, we write opinions. That's what we do. That's what I did, what I've done for most of my time as a lawyer. Hundreds of appeals. I actually argued in the Supreme Court 50 times before I was elected to the Supreme Court. And I think that that breadth of experience and that experience really led to the fact that 200 judges throughout the state have endorsed my candidacy in recognition of the fact that I have the experience and I'm there now doing the same sort of thing, doing an excellent job.
So here's another opportunity to try out your 1-minute storytelling skills. It's also, I think, along the lines of getting to know you better. What has been your most satisfying legal experience? Please explain why. And I'm sorry to say, Mary, you get to start. You don't have time to think.
Gosh, and I feel like a broken record. And I don't hopefully come across as nostalgic about the trial court, but to me the most significant experience has been my life in the trial court is actually listening to cases, assuring everybody due process. Every sentencing hearing really makes a difference. People think that it's easy to do that, but it's not. When you have to look at somebody in the eye and sentence them to prison, it's not easy. And those experiences inform my judgment today. So they're not only valuable, but I would say life-changing. Any judge who's ever had to do any of that or listen to a broken family, those experiences, again, speak very loudly and inform me today in a very deep and profound way.
The opinion writing is incredibly challenging and satisfying, so I very much enjoy and relish every case that comes in front of us. But in terms of what I take a lot of pride in, it's looking at the system to try to find ways to make it better so that it actually works for everybody. And as the chair of the Gender and Justice Commission since 1998, there have been 2 events that I would like to highlight. The first was we became aware that women in our prisons and jails were being shackled during delivery and labor. And we found that just to be a remarkably unfair position to put women in. And so we went to the legislature through the commission and other stakeholders, and we had the law changed prohibiting the shackling of women during labor and delivery. The second was the killing by the chief of police of Tacoma. He had victimized his wife. She had made many complaints about domestic violence. She got no satisfaction, and we changed the law for her.
I think there are many on both the criminal and civil side, but I'll circle out 2, one in broad sense. On the criminal side, I love every day being able to impact for victims and for our communities, and also working to help the defendants in that process as well. On the civil side, I think the most pleasure I've ever gotten was after some immigration raids in Ellensburg, actually starting a lawsuit naming the state of Washington as a plaintiff so that they would have to find a young man, a dependent of the state, then working through the system, becoming a foster parent to that young man who had coached his soccer, getting him then working through the federal laws to be now eligible to become a United States citizen in 2 years. So that was on the civil side. There's many, but helping that young man, taking him in and getting him on a pathway to citizenship was really something I thought was wonderful.
I tell people my motto is no repeat customers. And the other thing is I run a repair shop, not a junkyard. And I talk about the magic of dignity and respect, how you treat people. And what I tell you, about once every 1 to 2 months, I get somebody in my community, I've lived there 49 years, coming up to me and saying, thanks for changing my life. The one story, I was flipping pancakes for a fundraiser, and this woman comes up and says, are you Judge Larson? I said, yes, and she gave me a hug. She had been in my court 2 years early, chronic alcoholic. It was a 3rd or 4th DUI, long time in jail, and she was up at the bench, up at the bar, crying, bawling her eyes out. And see if I can get this out. Apparently what I said to her is, you'll get through this. And that made the difference in her life. She changed her life because of that one thing the magic of what we can do in this justice system is amazing. If you just give people the opportunity and dignity and respect, and that is the most satisfying thing you can imagine.
It's hard for me to pick out one case that was the most satisfying legal experience, so I'm just going to tick off a few. One was representing a fellow named Jesse Magana, who was injured, rendered paraplegic by an automobile accident. The automobile company lied about the prevalence of similar accidents, and it took years for us to figure that out and to undo that. And that was most satisfying when we did, and he recovered. Another was the Microsoft permit temp case. You might recall when Microsoft has employees that are permanently temporary. And I represented the plaintiff class on appeal. It resulted in a $97 million settlement for the class. I then represented the lawyers who had hired me in getting a $27 million fee from that. And I didn't get any piece of that, by the way, unfortunately. And then really representing folks in legal clinics.
Okay.
About 7 or 8 years ago, I was asked by the Office of Public Defense to help out in Grant County with the representation of parents whose children, whose parental rights were under attack by the state, by DSHS. And in order to ensure that there's a fair process, just as there's a lawyer appointed for criminal defendants, if you're a parent and the state is trying to terminate your parental rights, you're entitled to a defense of your parenting. And so I represented a young woman who had struggles with drugs. She'd lost custody of her child, and she was in the process of having her parental rights terminated if the state was successful. And as I prepared for the case, I listened to her carefully of all the things she wanted, making sure that she was really ready to parent her child if she were successful. And at the end, she came back to me and said, you know, I've decided to let go and to accept this termination, but because you treated me with such respect, I'm able to accept that result.
Thank you for the 1-minute stories. Much of the workload of the Supreme Court consists of criminal cases. What is your personal, professional experience handling criminal matters? How has that prepared you to serve as a Supreme Court justice? And we'll begin with Barbara Metz.
Actually, it's not a large percentage of the cases that we accept for review. Of course, they do come up in the motions and petitions for discretionary review. However, my entire background up until I joined the municipal court in Seattle was doing criminal defense and criminal prosecution, so I have extensive experience in doing that kind of work.
I think 22 years as a prosecuting attorney and also as a defense attorney, trying cases at every level of the court related to criminal cases as well as the civil cases that come up. I think that when we look at the criminal cases, oftentimes as a prosecutor, I have watched this court make mistakes in the criminal realm. And I think it's because they don't have on the court a prosecutor with a breadth of experience. Justice Mattson even talks about being a prosecutor in that experience, but that was mostly in the municipal court. In terms of my litigation expertise, it spans all of the courts in the state of Washington, and it spans every level of case that can be tried, as well as juvenile. And so I think that I could handle the criminal cases fine.
For the last almost 9 years, I've done about 85% of what I do is criminal cases. On a Tuesday morning, we might handle more cases that, in a Tuesday morning, might handle more cases than the Supreme Court takes in a year. So that's a large volume of criminal cases that go through our court. When I was in law school, I worked full-time, went to law school at night. I worked for the Pierce County Prosecutor's Office. My second year, I was involved in a police misconduct case, which involves a lot of criminal procedure. I was involved in some pretty significant litigation back then as a student, as an intern, writing briefs and everything, including the Pierce County racketeering cases that occurred in the late 70s. So my involvement with criminal procedure and criminal law was way back to law school. Became a civil lawyer for 23 years, nothing but criminal for the last 9.
For about half of my career, I have really practiced both civil and criminal law at the appellate level, and a whole variety of cases, rather serious cases, some rather complex cases, others. For example, we handled the appeal of Gordon Waldron in the GAM scam case, which goes way back, but that's an example of the type of case that we did. And occasionally, appellate work led into a trial case as well. After I won an appeal and got a new trial for a fellow, he talked me into representing him at the retrial. Spent 2 weeks trying a Class A felony case and wound up with a hung jury, so that he then pled guilty to a much lesser offense. So I've had a good deal of criminal experience at the appellate level in all kinds of crimes, mostly serious crimes.
My actual practice experience with criminal cases is fairly limited. When I was an associate at Lukens and Annis in Spokane, we did have some criminal cases in which I participated and represented criminal defendants. On the other hand, I've taught criminal law at Gonzaga Law School for probably on 20 different occasions. And criminal law is one of the most important measures of the success of our legal system, because it's the ultimate confrontation between the individual and the state, and ensuring that we have both the protection of the public through the proper enforcement of the criminal law, but also the criminal law is enforced in a way that's fair. We've already had some reference to the doubt that many people have that there is fairness in the system, but ensuring that our criminal justice system is enforced in a fair way is one of the most important tasks of our legal system.
I have had a lot of experience presiding over criminal trials, and that can be simple drug possession cases to very complicated murder cases. So I feel, again, that I've had the breadth and depth on criminal law. Since I have a little extra time, I just have to say this, is that you are measuring our abilities as of today. And my Chief Justice, she has sat on complex criminal cases for 23 years on the Supreme Court. So minimizing her experience as a misdemeanor trial court judge does not capture her competence and ability today on the Supreme Court.
Okay, let me ask you about a term that we often hear in connection with Supreme Courts, and that is judicial activism. What do you think defines judicial activism? Under what circumstances is judicial activism appropriate or even recommended? Please give specific examples. And we are going to begin with Greg Simple.
Well, judicial activism is defined very broadly as judges who are taking steps to move agendas forward, belief systems forward. When I look at the Supreme Court, I would say that the charter schools case is an example of the Chief Justice writing an opinion that could be called judicial activism. When I hear the Chief Justice talk about taking steps to further justice by going to the legislature and asking them to take action on a variety of topics and subjects, whether it's public shackling, whether it's you name it. The problem with judicial activism at its core is that if you, and particularly at the highest court, are out leading the charge on social issues, then how are the people who are coming before the court to litigate those issues relative to their rights, how are they going to feel that they're getting a fair shake if you're, as a court or as an individual justice, out taking the lead?
Well, I'm going to talk about the difference between perceived activism and actual activism. Perceived activism, everything's political these days. I mean, in some cases, you can't even read the law verbatim to people without them getting angry at you for reading it verbatim. And so they think you're an activist when you're reading the law verbatim to them. And so it's a lot of politics has been foisted. That's the kind of the appearance of activism. True activism, the kind of real activism, is where you cherry pick the law that you like and ignore the law you don't like to get a desired result. And one of the reasons I'm running is because I believe that that is happening. Whether people agree with me or not, I do, and I've looked at the issues, I looked at several issues, and I think that's happening. And when you cherry pick the law you like and ignore the law you don't like, That is the kind of real activism that destroys confidence in the judiciary. And I think that's what we need to avoid. And I say that with the utmost in respect, because I like everybody, but we have a problem.
I think that judicial activism really is kind of a pejorative term that really means you don't like the result that the court reached. But on a more serious level, I think it really is a taking leave of the text of what it is you're interpreting and ignoring that and going off on a wild tangent. Now, to speak to the example by Mr. Zimpel, the charter schools case, if you read that case, you'll see that everything in that case is based on the language of the Constitution and the language of the statutes and the language of prior case law. Those were the boundaries within which we stayed quite carefully. As for going to the legislature, the Constitution charges the Supreme Court with reporting to the legislature annually areas where the law needs improvement. So it is a command that's within the Constitution.
Okay, we have our first challenge of the evening. If I remember my own rules, it's a 45-second challenge followed by a 45-second response from the individual being challenged. So I guess we need to start with, who are you challenging?
Just Justice Wiggins.
Okay.
I have the Bryan case that the court used in the charter schools case. The way that the court quoted it, it said, the words common school must measure up to every requirement of the Constitution and whenever by any subterfuge. And they had an ellipsis. So I looked at the actual Bryan case, and they left out the words "and Code of Public Instruction," which completely eliminated the effect of the RCWs. That's activism, ladies and gentlemen. You don't take language out of quotes that are meaningful to come up with a result to say that school boards are required by the state constitution. Where's Elmo is the game. Find the language in the state constitution where school boards are required. That is activism, when you take language out of a case.
What the court did in that case was to really follow the Constitution and the law. And what they were looking at was, well, what is a common school? Because that was the term that's used in the Constitution. And they asked, well, what was a common school at the time of statehood? And that's what the court looked at in the Bryan case so many years ago. Now, Judge Larson likes to pick one phrase out of the case, and he ignores the principle that you have to read cases as a whole, because he doesn't go to the next page, which clearly says, here is a common school, and it's what's in the Constitution, and it's based on the constitutional language. And you do need to read the whole case.
Okay. Back to the question, I'm happy to repeat it too, if you've been distracted by the challenge.
What is judicial activism? Is it a problem? 6 years ago, I moderated a debate between then Justice Sanders and candidate Charlie Wiggins, and I asked the question, is judicial activism a problem? And both of them answered no. And in an interview with the Seattle Times, they asked me, so Professor DeWolf, what's your answer to that question? And I said, judicial activism is more than just a pejorative term. It's not just an epithet applied to cases we don't like. Judicial activism is where the court intercedes in an area where it believes some other part of the government is not doing its job, and it believes it has the authority and the competence. And I would say the McCleary case is the best example where the court has justified its taking over the legislative prerogative because of the justification that it's needed to do so. And that, to me, is judicial activism, and it's wrong.
Judicial activism is actually approaching a case with the result in mind and disregarding the law. To me, it's that simple. And I would agree with the comment that was made, that people accuse us of being judicial activists because they don't like the result. And the primary driver of all of this has been the McCleary decision, as if we went looking for a case to talk about education. The case came up through the normal process, through the trial court, came to us to address a constitutional question that we answered. They don't like the answer, and that's why we are being called judicial activists. We issued an order that said, It's a paramount duty. People don't like it. We're trying to enforce our order. Frankly, it's not all that complicated, but I would really beg to differ that we are judicial activists on the McCleary decision.
Two cases have been highlighted. One, the charter school case, and that not only did the trial court rule that the charter schools were not common schools, but 9 of the 9 justices ruled the same way. If you want to call that maybe it's a conspiracy, perhaps, but it's certainly not judicial activism. And I can't say it better than Justice Yu in terms of the McCleary case. That was not judicial activism. That was the Supreme Court of this state upholding the people's right to have redress against their government. If you have a constitutional guarantee that you can challenge the actions of your government in a court of law, then it follows necessarily that there is relief when you win in your lawsuit. And that is what the McCleary case has established, is that the court passed its judgment and that it will see to it that the judgment is enforced in the ways that the court has and in the tools that we have to do so.
Okay. We are going to move on to, it's 7:50, it's time for audience questions. We have some really interesting questions from the audience, so I want to launch into these. And I want to begin with, 2 of the questions deal with the idea of outside influence and campaign contributions to judicial candidates. So I'm going to blend the 2, but the question really is, how will you ensure that the judicial branch is not influenced by the lobbying, special interests, and public sentiment that so greatly influences decision-making at the executive and legislative branches of state government? Specifically, how will you deal with the special interests that have contributed to your campaign? The follow-on question from another audience participant is, to what degree does your financial support or the financial support you receive in your campaigns affect your decisions? And we're going to begin with Dave Larson.
Would have to get me with the toughest question. The money, I'm all in favor of public financing of judicial elections for this very reason. The idea that money's involved and the recusals we talked about earlier, and everything else. I think there has to be disclosure of who's given to who and those types of things. But as far as the personal impact, you have to have the courage to overcome. It's required in our ethics rules that you have to make decisions based on the law and the Constitution without regard to outside pressure. And if you make a decision against somebody that gave you money, or then that just has to be the way it is. But it is a problem when it comes to the campaigns themselves having to go out and get money. It's a big issue. As far as independent expenditures, we don't control any of that, and that's another big issue that creates confidence issues. But there's nothing we can do about that, both legally and otherwise.
Of course, the independent expenditures is the money spent not by the candidates themselves, but by third-party spenders.
In 2005 to 2006, I lobbied the legislature, along with some other folks, to extend to judicial races the same campaign finance limits that apply to all other statewide offices, all other state offices. Oddly enough, until 2006, there was no limit on how much money you could give to a judicial campaign. And I thought that was wrong, and I lobbied for it, and the legislature changed the law. I'm very proud to have been part of that. I also agree with Judge Larson, candidate Larson, about the public financing would be a great idea. The problem is that the United States Supreme Court has made public financing and most limits on judicial campaigns or judicial fundraising almost dead letter through the Citizens United case, and that's been a disaster. Finally, I don't think I'm influenced by the campaign contributions that I receive. I was accused of that in the WEA case, and I'll stop.
David DeWolf.
I think the idea of exerting government control over the spending, aside from disclosure, but trying either to do public financing or to put limits on campaign contributions, the cure is worse than the disease. The importance of judicial elections is that it's a means of holding our governmental officials accountable in the same way that legislators and the governor are held accountable through the election process. Judges are held accountable through the election process. And in order to allow for a real campaign challengers need to be able to raise the money to express their ideas and explain to the people why they need to be elected. And so efforts to control that process, I think, would lead to a kind of calcification of the process and really undercut the idea that elections really hold our public officials accountable.
I think ignoring the money is naive in some sense, so I like the limits. We have right now a $2,000 limitation on contributions. I'm comfortable with those limitations, have no dispute with the limitations, and I also love the fact that it's all subject to public disclosure so that you can actually see who's making contributions. I can just tell you that in our decision-making around the table, you have better be able to articulate the reason for your decision based on the law. There is no just saying because you think this and you're wanting to do a favor for somebody else, that's never going to pass muster. That's not how we do our job. And I can just tell you, it is not based on who contributes to our campaigns. I've raised the most money in this campaign so far on my own, and I'm proud to say that the majority of the money has come from over 1,000 individuals with the average contribution of $200. Those people I don't know specifically, but that's who's contributed to my campaign at this point.
I think that the limits that have been set by the public disclosure laws for candidates is the best judgment that we have in terms of what can be contributed without corrupting the candidates. So I think the $2,000 limits were the best judgment that these small amounts are not going to influence judicial decision-making. And I absolutely believe that to be true. I'm more concerned with special interest money. I have discouraged anyone that is listening from contributing to PACs or special interests that would favor me. My opponent has said several times he's very proud of the fact that he has special interest PACs that are contributing and are involved in his campaign. I think that is unfortunate because I believe that it does undermine the public's trust and confidence when they see hundreds of thousands of dollars as was dropped in the primary in my race. I think people have a lack of confidence when that happens.
Chief, if you're going to quote me, let's do it correctly. What I said was that I was humbled and thankful that the individuals spent the money the way they did. I was also thankful that it was you who told me that people were spending that money on me. I had no idea they were until you pointed that out at a forum. I think that if the chief is going to be upset about that, she should start the discussion on the biggest contributor to Supreme Court candidates and races and the biggest plaintiff in front of the Supreme Court, and that's the WEA. Shifting gears, I fundamentally believe in the goodness of people. I believe in the integrity of people until they show me wrong. For 22 years as a prosecutor, I've had to fundraise, I've had to have supporters. I've also had the displeasure of having to prosecute some of those people, making decisions that made them not be supporters in the future. It's your integrity, it's what you do as an elected official.
Okay. I have a pair of questions that deal with fairness in the system, and specifically the first question has to do with racial bias and how it affects our criminal justice system. And the question is, what role do you believe the court has, if any, in developing more fair outcomes for all people, regardless of race? And the follow-on is, what is the judicial branches and perhaps the court's role in promoting criminal justice reforms that would reduce, in this questioner's mind, the overuse of jails? And we're going to begin with Charlie Wiggins. Yeah.
Just maybe
Yeah, I'd be happy.
that two-part question.
Yeah. It has to do basically with what role does the court have in developing more fair outcomes for all people regardless of race? And I would blend with that a question about whether criminal justice reforms specifically are something that need to be considered by the court or the justices or the court system. The concern by the question asker was about the overuse of jail. So, bias in the system, overuse of jail.
With respect to bias in the system, I think that we have a racial minority and justice commission that deals with these problems and looks at these problems and investigates them. Our responsibility, I think, is to deal with them as a Supreme Court on a case-by-case basis. And I've written opinions that have called out areas where we need to correct problems of racial bias or racial really disproportionate treatment of minorities within the criminal justice system, and we are making progress on that. We're moving ahead on that. It's an ongoing problem. In terms of the judicial branch and the responsibility for use of jail and prison time, that's a legislative matter. We can certainly call for that or advocate for that or urge that, but it really is something that's in the hands of the legislature.
One of the critical things that lawyers struggle with is we tend to decide things on the basis of intuition, what we think is likely to be the case or what policies are likely to flow from what actions. And it's a challenge for us to incorporate actual empirical evidence as to what's really going on. That's certainly what's happening in the profession of medicine. We're trying to make the practice of medicine based on evidence and what actually solves problems. It's a critical question for us in the criminal justice system to determine the effect of race. When I teach criminal law, there's a famous study about the death penalty showing the comparison of the likelihood that a person will be sentenced to death. And surprisingly, the empirical study did not reveal a disparity between white and minority defendants. It did show a disparity in the identity of their victims. But again, what we need is real empirical evidence to determine the scope of the problem.
I hope that I have not just heard a question about the reality of over-incarceration of African American men, because that's a fact. The evidence is in that there is an over-representation of minority populations prosecuted by our criminal justice system and incarcerated. So to me, it's a fact. It's undisputed. The evidence is there. I think the courts have a particular role to play in terms of a leadership role, and that is we're responsible for court rules. We're responsible for ensuring that we administer justice fairly and accessible to everybody as best as we can. One of the issues that we are dealing with today is a court rule, 3.2, that has to do with incarceration before adjudication. 40% of the people in our county jails are sitting there in jail, and they have not even been tried yet. There's a whole presumption of release under the court rule, and what we are actively doing now is trying to figure out what tools we can give to our judges so that presumption of release is a reality.
I'm very proud of the work that the court does on racial disproportionality. It's our system, and we have to hold up the mirror, and we have to recognize when we're not doing enough to make sure that everyone is treated fairly. And so for the last probably 5 to 6 years at least, we've been having annual forums that we conduct in the Supreme Court courtroom, and we hear from people about the impact of our processes on people of color. And I think it is important for the court to take a leadership role, because who knows the problems better than the court and the judges who are involved in the system. I'd also like to say that we did a study on the perceptions of justice through the Minority and Justice Commission, and the perceptions of communities of color, it's not good. They don't perceive that they're being treated fairly in the system. One of the places that they identify is in the police and prosecutor aspects of a case. So the prosecutors in our state have an amazing amount of discretion as to what they charge and who they bring to trial.
I think I'll just start with the fact that when you want to deal with these issues, you have to be committed at the ground level. I've been the longest serving member of Fight Crime, Invest in Kids, an organization that works on overcoming the lack of education of those in poverty, those who are in abusive relationships, focusing on getting those kids a start at the front end. The greatest enabler of equality is education and removing poverty. You have to start in that level. You also have to address these issues at a community level, that you have your communities working, you have your leaders in your communities working, your discussions are happening, and your legislation is following up based upon that. Philosophically, this is a huge difference. The Supreme Court cannot be a leader on these issues. It's good for self-reflection in the mirror, I get it. But if you're adopting rules, if the legislature is passing laws, the place that they get challenged, the final decision made is at the Supreme Court. If you're out leading the charge and you're forming these rules, you can't be fair.
Can I have you tilt your mic just up a little bit as you, yeah, just like that.
You know, Martin Luther King talked about his dream, and it's kind of a nightmare in recent years. The answer is where the rubber hits the road. It's back to dignity and respect. I had an African-American defendant who had been a chronic criminal who was in custody and about to be sentenced, and he said, Your Honor, I see you in this community. I see you working at the concession stand for Kiwanis. I see you doing all this stuff. He says, I want to be like you. We have to model from the bench. We have to model the behavior. We have to show dignity and respect. I get defendants telling me, you're the first judge ever told me what I really need to do. But I tell you and race is a big issue, but I tell you what's even more sinful is the 40% of the people in jail are mentally ill. We're getting killed in our local communities by untreated mental illness and addiction. We have a Gender and Justice Commission. We have a Minority and Justice Commission. We have all kinds of commissions. We need a Mental Health and Justice Commission. We need to get the judiciary involved in being a partner in solving this issue. It is, and we don't have enough time to talk about it, but it is an epidemic.
This is another audience question, responding to something that I think one of you said. One of the candidates mentioned the importance of applying the law as written. What does that mean? Is that the only or best way to apply the law? I think we're asking for the non-attorneys in the room to give us a little bit of an education and your view on this, and we're going to start with David DeWolf.
Well, the process of interpreting either a statute or the Constitution is a process of trying to determine the intent of the people that wrote the statute or the Constitution. And that is framed by the context in which it occurs. We have rules for interpreting contracts where we incorporate the context in order to determine as best we can what did the people who entered into this contract intend. With respect to other issues, a lot of times the court is not dealing so much with interpreting a particular statute or constitutional provision, but is trying to reconcile a tradition of cases of previous precedent and determining the relative weight to be given to precedent as distinguished from other considerations such as changes in society or changes in the conditions that make that precedent either binding or not. So it's a complex process in which judges have to use their best judgment as to how the law should be interpreted.
You know, I think this will probably be one that we sort of build on the answer, and that is, when we talk about the law as written, we're really trying often when we look at a statute to interpret literally the words on the page. Does it make sense? Can we understand what it says? And there are actually rules, or if you will, canons of construction of how we would look at the words as written. And if it's ambiguous, then we also have a set of rules that says, then how do we somehow either look at other provisions in terms of not just that section of that statute, but can we look at that whole section and make sense? And if not, then we go to legislative history to try to determine or ascertain what was the intent of the legislature in adopting this particular provision. So when we say trying to interpret the words as written, that's where we start, and then we begin to build. And again, looking at legislative history, which possibly could include testimony, could include the decisions or some of the words that some of the legislators used in terms of what they intended and what they meant.
So I can't really add much to what Justice you and Mr. DeWolf have said. We're really wanting to carry out the intent of the legislature. If it's a statute, we want to carry out the intent of the drafters of the Constitution. If it's a constitutional question, we have these rules of statutory and constitutional construction that we adhere to, and a lot of that is so that we have predictability in the outcome. It also, when you ask that A question, the activism question, you can read the opinion and you can say, no, the court actually applied the rules of construction and they got to this very rational result. And that's what makes our Supreme Court actually I believe it's the second or third most frequently cited court in the country. And when courts are citing, other courts are citing your court, that means that you're doing something quite right.
Can't add much to the definitions. We'll say that it's always interesting to talk about what the court is being cited for or not cited for. But it's also interesting to hear the Chief Justice talk about predictability because One of my concerns has been the lack of predictability of decisions she's written. One of them was in PRP of Andrus, where the Chief Justice authored opinion without a change in the statute, with decades of practice by prosecutors, defense attorney, trial court judges, looked at a particular statute, said that we can't tell whether the legislator intended to include felony murder, assault and felony murder, because we think it's unfair. We're going to change that and say it did not include it, overturn those precedents, sent 285 cases back to the local level. Legislature special session immediately said, you're wrong, we always intended to have that in there. We're going to go into special session just to reaffirm what we did. I agree, predictability is important. This court, under the Chief Justice, has lacked some of that.
Well, we have statutory law, the law that the legislature develops that we all agree to abide by. And so when we're predicting our behavior, we got to be able to look at the law and say, this is how we need to behave. And if somebody says, well, I don't agree that that's how it's interpreted, I'm going to put my own twist on it, then it's very hard to predict the legality of our behavior. So you have to read the law as written, because everybody's trying to abide by that law. It's just very practical. And if the judges end up reading something into it, then it becomes chaotic and people have a sense of injustice. There's also case law. And go back to the charter school case. The last sentence of the case says it's not the legislature cannot make provision for the support of a model training school, but attempt to do so as made provision out of the wrong fund. That case is about the Common School Fund. The legislature in 1911 funded the model training school out of the general fund. And that's the last sentence of the case. Ignored that and said you can't fund it at all, a charter school at all, even though the case in the Bryan case said you could fund out of the general fund.
School funding has changed quite a bit over the years, and it certainly has changed since 1909 when this case was resolved. And so you can't just look backward and say, well, that's different. So I don't agree with candidate Larson on that. But I want to talk about applying the law as written, because we've all talked about it. That is part of the separation of powers. If we weren't limited to the law as written by the legislature, we'd be a super legislature ourselves. We're not a super legislature. We follow the law, we read the words, we try to give meaning to every word, we try to not to take words out of it. And this does lead to predictability. It does lead to stability in the law. And we don't overrule our own cases without the discipline of finding two things. Before we'll overrule our case, it has to be harmful and it has to be wrong. And so both of those things have to be present in order for us to overrule our own case.
Here's another audience member question. The administrative offices of the court are underfunded. This is not good for justice. What do you think should be done about this? Mary, we'll start with you.
I think it should be funded more. I don't mean to make light of it. The Administrative Office of the Courts, for all of you who might not know, is a large agency that supports trial courts, Court of Appeals, and Supreme Court across the state. So they support all the technology, the education, payroll. It literally is the infrastructure of the court. So when we don't have, frankly, a laptop or a computer, we turn to AOC to ask for support and resources. So you can see that the pinch at the trial court level, whether it's at the municipal or again at the Superior Court level, the pinch is because AOC doesn't have the resources often to serve many of the trial courts. So I would say it ought to be funded more. The very difficult question is, of course, the limited revenue that's available, and we're not at the top of the pile when it comes to what should be funded. So I do think it ought to be increased, just because it would strengthen and support trial courts around the state as well as the appellate courts.
And of course, there's no obligation to use your full minute. If you want to be brief, we'll just ask more questions, but don't feel obligated.
The Administrative Office of the Courts is an incredibly important agency within our state. And the reason that it's even more important in our state than other states is because we have a non-unified court system. And what that means is that each local jurisdiction pays the cost of their court system. And we know, because we have different geography in this state and different tax bases, that leads to a less than uniform system of justice across our states. So the Administrative Office of the Courts is the place where it tries to lend that support to all of the courts to bring everybody up at least to an equal level. It's a floor, but it's certainly not a ceiling. Many courts are able to afford much more in the way of resources for their courts. So the Administrative Office of the Courts is just critical to those underfunded courts across our state. I have, as the Chief Justice, gone numerous times to the legislature to make the case for the courts and the need to fund AOC.
The question begs an answer that the AOC is underfunded. That's a question I think that might be best looked at. Are they underfunded or are they trying to do too much? I think that too often the court and AOC have tried to step too far abroad in doing what they need to do. Trial courts are very good. They have very good people. I think that if you look at the fights that have been picked between county clerks and AOC, if you look at the problem with the forms that they have had, if you look at their budget and rolling out a case management system, there's problems there. I'm just not certain that it's a matter of funding. I think it's a matter of getting back to what their core mission should be and sticking with that.
I'll start out by saying I don't know what came first, the chicken or the egg. All I know is a bunch of chicken feathers to clean up, because the relationship between the courts and the legislature is an all-time low. Whether you agree or disagree with the court, this is very factual, and you can sympathize with the court or you can sympathize with the legislature. You can think the legislature is wrong or you can think the court's wrong. The people deserve better than what we're getting, and we need to figure out how we fix that relationship so that there isn't that tension. Keep in mind that the McCleary case is talked about and the charter schools case is talked about. 5 former governors, 3 Democrats, 2 Republicans, opposed the contempt finding in McCleary. 5 attorney generals, the current one and 4 previous ones, asked for reconsideration of the charter schools decision because they unwittingly declared all kinds of other programs unconstitutional. And with that, and when you do things like make the parties respond to the type of things that have occurred in McCleary, whether you intend it or not, you're creating division. And what's happened is it's been, whether you like it or not, it's been a reaction to the courts to cut our budgets. And that's one of the reasons I'm running. We can maintain judicial independence and keep our relationships.
Let me say a few words about the McCleary decision. The Constitution of the state says the paramount duty of the state is to provide amply for the education of the children of this state. After a lengthy trial, the trial judge found that the state was not doing that. That case came up to us, and we looked at it, and we agreed that the evidence showed that the state was not doing that. And we said, okay, legislature, you have defined what is basic education. You said this is how we're going to fix it. You said that it's going to be done by 2018. Now you need to do it. That is what the McCleary case says. Should we have tried to enforce the McCleary decision? If we had not tried to enforce the McCleary decision, we'd be nowhere today. And yet there has been progress. The state itself admits that there has been progress made, that the contempt and the fine really moved the legislature forward. A couple of $2 billion has been added to the budget. More needs to be added.
Okay.
I think this illustrates the principle of judicial activism. It's achieving a result, which is better education funding through the use of the court's power, literally to hold the state in contempt. And the question started with the Administrative Office of the Courts, and again, this bad relationship was created by a court that has held the entire state in contempt and really poisoned the well in terms of the sort of relationship that the different branches of government need to have. With respect to McCleary, again, these extraordinary remedies are as though this were an ordinary case, an intersection collision case decided by a trial judge. Under what principle does a single trial judge get to decide what is ample provision for the children of the state of Washington? What is education? That decision can't be affirmed in the same way you would affirm a decision in a medical malpractice case or an intersection collision case.
We have another challenge. We have 2 challenges.
Oh.
Okay.
Did
Now
I
you're going to
jump
really,
in?
this is going to make me work for my,
I'll defer to the chief.
well, you're welcome.
Well,
I think you both have one.
I think it's important. Several things are important. One is
And
that.
just to be clear, who are you challenging?
It's sort of a general challenge,
Okay,
I
I
have
think
to
you have
say.
to, but I
So
think you
every
have
one
to.
of us gets 45 seconds?
Yeah, right.
oh,
Well, I guess
well,
I'll
I
have you
don't know.
challenge. The last speaker was David DeWolf,
All
but
right,
if you
then,
were.
then I will challenge David DeWolf,
Okay.
how's that? It's really, it shows a lack of understanding, I guess, to put it in the best way possible, of the relationship between the court, the governor, and the legislature, to say that our relationships are so poor that we haven't been funded. That does not begin to describe the relationship properly. I meet quarterly with the governor. I have always met quarterly, and I continue to meet quarterly to talk about issues that we have in common. I meet with leadership in the legislature on both sides of the aisle frequently. We've been through a recession since 2009. That's why the courts haven't been funded.
Okay, David DeWolf, you get 45 seconds to respond.
Well, the question remains, however, how is it that we can improve the relationship between the courts, which have to perform their function, and the legislature, which has to fund the courts, in deciding the McCleary case and literally holding the state in contempt, and basically treating the legislature and the governor as though they were deadbeat dads who hadn't fulfilled this constitutional responsibility? That really has poisoned the relationship. You can talk to many legislators who are very unhappy with the way the court has treated them as a co-equal branch of government.
Okay. Would you like to mount your challenge?
Sure. I guess I'll direct this to my opponent, Mr. Larson, on the same question.
Judge Larson, please.
Well, I don't think we're supposed to use the
Well,
office as part of the
well,
candidate,
that's
Larson.
fine. That's fine.
His claim is that we poisoned the well. The fact of the matter is, education is the paramount duty of the state. It has not been done. In 1978, in the Seattle School District case, the court held the same thing. The state was not adequately funding education. And here we are, years later, and the state still has not amply funded education. And that is why we retain jurisdiction. And what are we going to do? If you believe we shouldn't do anything about this, you're saying, I believe in McCleary, and I believe in education. I just don't want to pay for it. That's really what's being said here.
Okay, now you're on my turf. I lived it as a student. I was a school board president. I wrote an op-ed about the screwed-up education funding in our state in the Seattle Times 4 months before McCleary was filed. I was an architect of the first lawsuit in this century to get education funding fixed. I'll read you something from, and again, the courts, everybody's missing the point. The solutions are in the weeds and they're not fixing them. It's like having a broken foundation and making them put a new roof on the house. This is language from a case they cited in one of their orders. Each of the 3 departments into which the government is divided are equal, and each department should be held responsible to the people it represents, and not to the other departments of the government or either of them. And they ignored a statute that limits, it's RCW 7.21.0302B, which limits sanctions and contempt to $2,000 a day.
I think this is a perfect note on which to ask our last question of the evening. And I think the question is perhaps timely now that we've seen a couple of challenges. The last question is, why do you think you have the temperament to be a good Supreme Court justice? And I believe we're beginning with Barbara Madsen.
I can't think of anything more challenging than being the Chief Justice with 8 other incredibly smart, committed, opinionated justices that I work with, and yet we are in harmony. We do not always agree. We have very robust discussions, debates. We have 5-4 decisions, but we are professional and we admire and respect each other. And so I think my temperament shows in the fact that I've been elected twice to lead this august group of judges.
Greg Simple.
I think it's important to have leadership. I think that when you have been a leader of county prosecutors, when you have been a leader of a large number of local elected officials, when you have had to work with 2 other associations to work together with the legislature after funding for local government was eliminated. When you have to work with defense attorneys, when you have to work with trial court judges to implement a drug court, when you have to work with the system and make systems work, those are things that I have done, and it's done out of respect. It's done because I have 2 ears and I listen very well and talk very little. It comes from providing everyone with dignity and making sure that as you reach decisions, everyone is involved in the decision-making process.
Go ahead.
I think judicial temperament is absolutely crucial for procedural due process, making people feel they've been treated fairly. There's a little bit of passion that comes every once in a while that has to be shown, but judicial temperament is absolutely crucial, and every day I have to exhibit it regardless of how challenged you are. Like I say, I'm getting paid back for all the times I blame the stupid judge for ruling. So, but ultimately it's one of the most important things we do is the way we treat people and the way we treat each other.
I love this job. I wrote 20 years ago, and I wrote an article on how to vote for judges and who should you pick for judges, and I listed a series of qualifications. And the last one was a heart for justice, someone who longs to see justice done, who has a burning desire to make sure that justice is done between the parties in a way that looks forward, in a way that heals relationships, and in a way that gives guidance to the future. That's what I have tried to do since I've been on the court, and I think that I've been successful in doing that. And I really would appreciate very much the opportunity to continue doing that for another term. Thank you.
As a justice, I would be one member of a 9-member body, and one of the critical things is to be able to get along with people. And I think anybody who knows me from my days at Gonzaga Law School would know that I knew how to get along with people. I could disagree with people without being disagreeable. And the essential thing on this court is to be able to explain ideas, to be able to argue the positions of the parties in a way that leads the entire court to the correct decision. And I think I have the temperament, the ability to get along with people, but the ability to articulate ideas well and to write successfully that would make me an ideal member of the court.
I would say some of the ideals, or what I personally have committed myself to in serving as a judge and now as a justice, is a commitment to civility, to being compassionate, to being a good listener, to be passionate for true justice, I think, as Justice Wiggins has mentioned it. And probably what would draw the distinctions between me and some of the individuals who are challenging us is not ideologically driven, and that is that there's a real openness to try to get to the right result in some way, and that it's not driven by ideology or a particular result. And then I just want to harken back to what the chief said, is right now this is a court that really differs among ourselves in terms of decisions, but it is so civil. And under the chief's leadership, it really has been one that's been very thoughtful, very deliberative, and one that's very respectful of differences. And you can see that in our decisions. We're not all 9-0 decisions. There are disagreements, but they're thoughtful and they're well-written, and we explain how we differ in the law, and I think that's what makes this court a very good court.
Okay. Keep in mind that the presidential debates were an hour and a half. We've kept these candidates, and you all have been sitting for 2 hours. I think the topic in these races deserved it, and in fact, in some ways, it got more interesting as we got into the second half. But this is all the time we have. I'm going to ask you to hold your applause for just another moment. On behalf of the League of Women Voters and the co-sponsors, I would like to remind you that this was recorded. It was recorded by Thurston County Television as well as TVW. The coverage will be available through links that will be posted to the League of Women Voters of Thurston County website. Thank you for coming to this forum, and please now join me in thanking the candidates.